topic is how shall we meet the challenges and opportunities under RA 10587 by Dr. Astia M. Santiago, ENP. This was during the 15th Integrated Seminar on Environmental Planning, March 31, 2016 at the University Hotel, UP Diliman. So a review, why do we need laws regulating the professions? So the reasons are to provide the high standard practice, promote intra and interprofessional cooperation and competition, contribute towards national development, protect public from unqualified and incompetent practitioners, protect public from malpractice or illegal practice. So historical notes, Presidential Decree 1308 under martial law was the first planning regulation law. So RA 10587 was the first comprehensive law regulating the profession. That's the May 27, 2013, Resolution number 3 series of 2014 or the IRR by the Board of Environmental Planning. So questions this presentation will answer: when are you consider practicing environmental planning in the Philippines? Aside from the regulated and the regulator, who are the other stakeholders, and how does licensing takes place? How can foreigners practice in the Philippines? When does civil liability of planners arise? What issue have arisen in the past years and how they've been responded to, and what new developments have been influencing the implementation of RA 10587? So why do we need this law? Underscore the importance of environmental planning in nation building and development. Second is nurture competent, virtuous, productive, and well-rounded environmental planners. Third, mandate standard practice in order to be excellent, world-class, and globally competitive. And how can we achieve this? Through honest, effective, relevant, and credible licensure examination and regulatory programs or activities which foster this professional growth and social responsibility. So some acronyms: APO is Accredited Professional Organization, duly integrated and accredited professional organization of the environmental planners, which there shall be only one prescribed by R 8981 or the Comprehensive Law on Regulation of Professions. BEP, Board of Environmental Planners, again CHED, Commission on Higher Education, CSC, Civil Service Commission, CPE, Continuing Professional Education, and EP, Environmental Planning or Environmental Planners. AAR, Implementing Rules and Regulations, on the Job Training, OJT, PAEP, Philippine Institute of Environmental Planners, PRC, Professional Regulation Commission, RA 1891, or the Comprehensive Law of Regulation. So what are the vital aspects of the law? Registration and licensure, of course, including exam, registration and licensure, control and regulation of practice, supervision, control and regulation of practice, curriculum development, of course, development, upgrading, updating of the curriculum. And continuing professional education or CPE for development, improvement of professional competence and practice. Establishing civil liability of environmental planners. Under the law, how should environmental planning also be known as its equivalent? So as urban and regional planning, city planning, town and country planning, human settlements planning. So first, it is a multidisciplinary art and science of analyzing, specifying, clarifying, harmonizing, managing and regulating the use and development of land and water resources. So in relation to the environments, the development and sustainable resilience, communities and ecosystem. So, and who and what are the pillars of planning profession? Of course, first the academe. This produce highly technical or just plainly technical skilled planners to pursue the practice of the profession, contributing to the significant national development. And second, the APO or the Philippine Institute of Environmental Planning, 1969. This is the professional organization organized to bring together the professional planners friends, promote the profession also, and provide the venue to its various chapters and fora for sharing knowledge and experience in planning practice. And third, establishing the Board of Environmental Planners, PD 1308, 1974, activated in 1992 and recognized as APO under RA 10587 in 2013. So C1 regulates the profession through licensing and administration of examinations, not only in the point to the official practice of the profession, guards the integrity of the profession by ensuring that only those who are statutorily qualified are able to enter and stay in the professional practice, protects the profession also from malpractice and unethical practices, contributes toward the enhancement of fashion by making it globally competitive. By integrating new technology and awareness of new knowledge through, among others, continuing planning education, and of course, co-sponsoring with local and international planner seminars, conferences on specialized planning topics. Who are the main stakeholders of the law? The regulated ENP, environmental planners, the regulators and our players, the in EPB, Environmental Planning Board, the PRC, or Professional Regulation Commission, and the PAEP, or the Philippine Institute of Environmental Planners, or the APO. Other government institutions in the academe, CHED, CSC, which creates positions, qualification standards for ENP in government service and government-owned and controlled corporations, and national government agencies and local government units. When can you be considered as an environmental planner? When you are registered and licensed to practice environmental planning, you hold a valid certificate of registration, you hold a PRC or identification card from the board. And how important is the registration? No person should be allowed to practice environmental planning without the certificate of registration. Otherwise, provided all prerequisites for registration are required to pass the professional licensure exam. Are there exceptions to the rule of no exam, no registration? Yes. Under vested right principle, if you're registered under PD 1308 board holder valid PRC professional IDs and is a PAP good standing member of APO, reinstatement, reassurance of revoked registration. And what are the requirements before you could take the exam? Of course, Filipino citizenship or foreign citizenship whose country has reciprocity policy of good moral character with no conviction or offense on moral turpitude, holder of prescribed academic qualifications from CHED accredited schools, acceptable degrees, a graduate degree in EP or its equivalent, a postgraduate diploma in environmental planning, plus at least 1 year of on-the-job training, a bachelor degree in environmental planning or its equivalent, plus 2 years of OGT, a master's or doctorate degree in architecture, ecology, economics, geography, geology, project administration, business administration, sociology, social science, law, environmental science, environmental management, natural resources, planning and development, and related principles, plus 3 years of OGT. A bachelor's degree in architecture, engineering, economics, law, social work, public administration, community development, or sociology and others, plus 5 years of OGT. And who are the others qualified to take the exam? Incumbent holders of planning positions in the national, including GOCCs, regional or local government offices, and have been engaged in development planning functions acceptable to the board, provided that they are holders also professional civil service eligibility. These are the additional pre-qualifications for incumbent officials to take the exam, and they have also undergone at least 80 hours of in-service training or distance learning in development planning from a duly recognized government agency, school, or institution. Important note, these professional listed paragraphs shall take the licensure exam within 5 years from the effectivity of the law. And what are the requirements for this OGT or on-the-job training? Supervised by a registered licensed NP or applicant's image supervisor in an organization involved in the environmental planning acceptable to the board. And the subjects of the licensure exam included but not limited to environmental planning history, concepts, theories, principles, the processes, methods, techniques, strategies, and the planning implementation, legal aspects, and administration. To pass, the weighted average is 70% and the rating of not less than 50% in every subject. Detailed coverage of subjects are in the Rule 3, Section 16 of the IRR. So how can foreign national practice the country without taking the license exam? By obtaining a temporary special permit from the board or approved by the PRC in Dole to practice in the project to which she was commissioned, but practice shall be limited to natural persons only, stated in Section 29. When may temporary permits be issued to foreigners? So compliance with the reciprocity clause, his expertise is necessary and reduced to the Philippines, must work with a Filipino counterpart, and non-availability in the country of competent, able, and willing person to perform the services for which expert was invited as determined by the board in PRC. So what activities will constitute environmental planning practice? First is the rendering of professional services, technical consultation, technical advice, plan preparation, capacity building, and monitoring evaluation of implementation of the following. So, national, regional, or local development, official framework, and comprehensive land use plans like CLUP of the local government units, preparation of zoning and related ordinance, code for the development, engagement, preservation, conservation, rehabilitation, regulation, control of the environment, including land, water, air, natural resources, planning and development of a barangay, municipality, city, province, region, or any portion or combination thereof. And development of a site for particular need or special purpose, such as that of economic or ecological zone, tourism development zone, housing, or other real estate development projects, creation of spatial arrangement of buildings, utilities, transport, and communications. In relation to the activities enumerated, following studies should be prepared, like feasibility, and other related concerns, environmental assessments, institutional, administrative, or legal systems. And the curriculum syllabi development in the licensure exam for planners and teaching in academic institutions and conducting review courses in environmental planning. And of course, serving as a expert witness, resource person, lecturer, juror, arbitrator in hearings, competitions, exhibitions, conduct of hearings, competitions, exhibits, and other public uses. And ensuring compliance with environmental laws, including acquisition of regulatory permits, performing other acts, activities determined by the board with PRC approval of the trend of the practice. And issues raised in responses hereto, availability of the grandfather clause can only be made available once in the statutory history. So taking the examination by those with prescribed timelines, professionals with academic degrees other than environmental planning, incumbent government officials who are not environmentalists shall take examination within 5 years from 2013 up to 2018. There shall be a review of government positions which require the knowledge, skills, competence, and qualification of planners to ensure that only licensed and registered planners shall be appointed to them, and otherwise appointments shall be null and void. An appointment to LGUs within 3 years of the validity of the law, or stated here up to 2016, LGUs may continue to issue appointments to persons who are not registered or licensed NVP for the positions of national or local planning and development coordinators, but only on temporary status or acting capacity, as stated in section 37. Clarifications of civil liability of planners in the case of damage, failure, and destruction of any project, subject, or covered of the environmental plan, resulting in significant adverse impact on affected stakeholders or the concerned ecosystem, section 35. When does civil liability of planners arise? When there is a serious, large-scale, or wholesale damage, failure, or destruction of any project, subject, or covered by environmental plan that result in a significant adverse impact on affected stakeholders or the concerned ecosystem, section 35, paragraph 1. So that such damage, failure, or disruption was foreseeable, could have been anticipated. Secondly, that they are directly caused by the gross negligence of the part of the planner and his team, by highly deficient or inappropriate environmental planning methods, strategies, or tools, or techniques at variance with generally accepted environmental planning principles, methods, and standards. The environmental planner in charge of the preparation of the environmental plan and related documents, as well as the other members of the planning team involved in the preparation, shall be subjected to civil liability in cases described in the law within a period of 10 years from the implementation of the plan, as stated section 35. So what new developments have been influencing the implementation of RA 10587? So just a summary of these developments. First is the integration in the CIAN in 2015, the creation of new planning related institutions, such as of the Institute of Urban Resiliency under EMI, July 2014, to develop competent practitioner in urban resilience to train knowledge and information sharing. Proposed creation of the Academy on Disaster Management by the Philippine Red Cross. Implementation of the ongoing programs including education for planners to mainstreaming DRR or disaster risk reduction management and climate change components, such as comprehensive land use planning in Makati and Marikina, continuing improvement of the more comprehensive HURB guidelines. So this is now the Department of the SUD now, increasing importance to the role of planners and other planning officials, such as that of building official and zoning administrators, increasing participation to the legislative and judicial branches of the government, and the growth of planning jurisprudence. And 2014 recommendations for the 8,000-page report for the Presidential Assistance of Rehabilitation and Recovery, or the PARR, the greater empowerment of planners and other planning officials, such as the building officials and zoning administrators, increasing the role of the judiciary, and the expansion and the growth of planning jurisprudence. And thank you for your attention.